5 affirmative votes, 19 negative votes. The motion to table the motion of Senator Marcoleta is lost. Lost. Sotto. Sorry, Senator Sotto is lost. No, he said the motion to table the motion of Senator Marcoleta is lost.
Yes.
Pati tuloy ako, nalito, Tito Sen.
Mr. President,
Senator Villanueva.
if I may, Mr. President, and to go back to the first motion raised by Senator Marcoleta, if I may be allowed, Mr. President, to amend, Mr. President, the motion, Mr. President.
The gentleman may proceed with the permission of Senator Marcoleta.
Mr. President, adhering to the immediately executory decision rendered by the Supreme Court en banc on 25 of July 2025, which held, among others, the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction over the same. I move to transfer the articles of impeachment in relation to case number 002-2011 entitled in the matter of the impeachment trial of Vice President Sara Zimmerman Duterte to the archives. I so move, Mr. President.
What does Senator Marcoleta say?
I accept, Mr. President.
There is a motion as enunciated by the minority floor leader. What is the pleasure of Senator Zubiri?
Yes, thank you, Mr. President. Mr. President, instead of a viva voce vote on that motion, may we be allowed to manifest our votes with a short manifestation, Mr. President, each and every one of us.
This,
Yeah, through nominal voting, Mr. President, with the permission of the body, of course.
no, I think, Senator Soto, the motion of Senator Zubiri is to conduct nominal voting and allow the members to explain their votes after casting their vote, not after everyone has voted. I think that is the tenor of the motion of Senator Zubiri.
Correct, Mr.
Ang binobotohan muna natin, amendment mo di ba? Tinanggap niya.
Hindi, yung motion na.
Tinanggap niya. So,
Yes.
Mr. President, the Majority Leader, Senator Marcoleta accepted the amendment of the Majority Leader. So, what are we voting on now? May we now...
The motion
hear-
as amended
Yes,
by
the motion
Senator
as-
Villanueva.
May we hear the motion as amended, please?
May the gentleman,
Yes.
the distinguished majority leader,
Yes,
kindly
Mr.
state
President.
once again for the record and benefit of our colleagues, the motion as duly accepted by Senator Marcoleta.
Thank you, Mr. President. Adhering to the immediately executory decision rendered by the Supreme Court en banc on 25th July 2025, which held, among others, that the articles of impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction over the same. I move to transfer the articles of impeachment in relation to case number 002-2011, entitled in the matter of the impeachment trial of Vice President Sara Zimmerman Duterte to the archives. I so move, Mr. President.
May we register, would anyone from the minority or those opposing the motion would like to make of record their objection before so that we can divide the House?
Yes, Mr. President,
Yes,
I
please.
object and
Thank you.
ask for a nominal vote.
Thank you. With the understanding, Senator Soto, that it is in accordance with the request of Senator Zubiri, that upon the name is called, the explanation of vote may be made, should they so desire. There is a motion duly objected to, as stated by the minority floor leader, to place into to transfer to the archives the impeachment articles of impeachment in relation to the impeachment complaint against Vice President Sara Duterte. Secretary is directed to call the roll and proceed to nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan.
Mr. President, sabi po ng preamble ng Philippine Constitution, we, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessing of independence and democracy under the rule of law, a regime of truth, justice, freedom, love, equality, peace, do ordain and promulgate this Constitution. Nanumpa po tayo na susundin natin tong Constitution na to. Madali pong sumumpa, mahirap to pa rin. Madali pong sumumpa na susundin kung naniniwala tayo sa desisyon. Paano kung hindi tayo naniniwala sa desisyon? Paano kung ang tinatanggal ngayong hapon na to ay si President Marcos at ayaw kong maging presidente si Vice President Sara Duterte? Will I have the courage to follow the same decision? That is the test I apply to myself today. Tinignan ko po ang Supreme Court decision, solid po. Hindi nito inaalis ang kapangyarihan sa House to initiate impeachment. February 6 po, sigurado yan. In fact, before February 6, may quadcom na, magiging glorieta na yan soon. Tuloy-tuloy po yan, yung mga investigasyon na yon, kasi ganun ang politika sa Pilipinas. I hope yung sa baha, imbestigahan din. I hope yung sa corruption, sa smuggling, sa karami-rami nating utang, not only this administration, last administration, 10 administrations. We in this room are all for accountability, but tama yung Supreme Court sa tamang panahon, tamang proseso. Jeremiah 29:11 tells us, "For I know the plans I have for you, plans to prosper you and not to harm you, plans to give you hope in a future." Plano ng Diyos, pagpalain tayo. Pero plano ng Diyos, durugin tayo. So, I remember this episode, I think it was in Twilight Zone, and it was also many, many times portrayed on television. What if nakilala mo si Hitler when he was 6 years old or when he was a baby, papatayin mo ba siya? I think even sa psychology or philosophy classes, tinatanong to ng mga professors, what if you had that unique opportunity, nakatabi mo si Hitler nung 6 years old siya, papatayin mo ba siya? Ang hirap sagutin nun. Of course, for us who believe that thou shall not murder, ang sagot madali. But what if you could have prevented the worst human rights violations in the world, the Holocaust? What if you could have prevented such fire of fascism that it actually swept, kung hindi ako nagkakamali, nag-Time Magazine of the Year pa si Hitler. I wonder what our answer is. But I know my answer here today. If you kill Hitler when you are 6 years old, if you justify the ends by the means, you will create more Hitlers. So if the Vice President is guilty, dapat po siya ay i-impeach. Pero sa tamang panahon at tamang proseso. Nagsalita ng Korte Suprema na mali ang proseso, mali ang panahon. But yun po, Mr. President, sana kung ano ang discussion since February 5 dito na nakatuon kay Vice President Sara Duterte, sana kung sino ang guilty sa mga baha, ganun din tayo. Hindi naman siguro si Sara ang gumawa ng mga baha. Sana po kung ano ang cause ng pagkabansot or stunting yung corruption, ganun din. Araw-araw talagang wag natin tantanan. Lastly, Mr. President, may I make an appeal to the media, our friends, the vloggers, yung iba nandito, political analysts, advocates, school deans, etc. Nakalagay kasi dito, we all agree on a regime of truth. Parati na lang ang vloggers ang nasasabihan na fake news. Alam niyo po, marami tayong political analyst ngayon, di naman sila analyst eh. Ang ibig sabihin ng analyst, provides objective, non-partisan, data-driven explanation of political events, systems, and trends. Ang ibig sabihin naman ng advocate, champions a specific cause, policy, or interest group to influence public opinion and policy decisions in favor of their positions. Wala namang masama dun eh. So kung ikaw ay advocate, sabihin mo na lang. Pero mag-a-appear ka sa TV, magpapa-interview ka, sasabihin mo political analyst. Pero gusto mo lang, bata mo maging presidente, nililito mo pa ang tao eh. Ganun din po, ilan beses kami binugbog dito nung iba na ang sabi, bawal daw ang isang senator judge na mag-move to dismiss. Pero sila din ngayon ang nagsasabi sa mga senator judge, mag-MR kayo sa Supreme Court. Saan kayo nakakita na hindi pwede mag-motion to dismiss? Judges dismisses cases because of no jurisdiction. Ang CA, 3 sila o 5. Hindi nyo lang nakikita sa publiko at hindi sila mag-move kasi sila lang nag-uusap. Ang Supreme Court, hindi ba dinismiss nila? Hindi ba sinabi nila no jurisdiction? Tayo kasi dito nag-usap sa hall na to. So natural, hindi naman pwedeng si Senator Batorni ay tumingin lang sa akin tapos maisip niya dismiss. Walang manifestation dito na hindi sinasabi. My point, Mr. President, is that yung sinabi ni Mahatma Gandhi nangyayari na sa Pilipinas eh. Sabi ni Mahatma Gandhi, if it's an eye for an eye, the whole world will go blind. Let's make our stand. Ilang beses ko narinig dito sa hall na to, ang taong bayan, ang taong bayan, ang taong bayan. Eh, hindi ba naman lahat naman tayo halal ng taong bayan eh, di ba? Hindi ba pwedeng sabihin ko na lang, ang opinion ni Alang Cayetano, isa lang naman ako eh. Ang opinion ni Joel Villanueva, ang opinion ni Mocha Uson, isa lang naman siya eh. Pero yung sabihin ko sa inyo, guys, ang opinion ng civil society, ang opinion ng masa, ang opinion ng taong bayan, dapat makonvict. Are we not overstepping and are we not confusing rather than enlightening our political processes? Yes, you might think this is a different Alang Cayetano from the impeachment of President Estrada, impeachment of President Arroyo, impeachment of yung hindi natuloy na impeachment kay CJ Davide, sa impeachment ni CJ Corona. But aren't we supposed to be wiser? At hindi ba tama naman yung sinabi ng Supreme Court? Dapat may impeachment pero hindi dapat gamitin ito ng magkalaban lang sa politika. Ayaw natin maging presidente si Vice President Sara, talunin nyo na lang sa 2028. Ngayon, kung talagang may ginawa siyang masama, edi impeach pero sa tamang paraan. I apologize if I'm emotional on this issue, but hindi tayo makawala eh. Ang daming mas importanteng issue, pero nakapako tayo sa issue na to. Thank you, dear colleagues, and thank you to the Filipino people for the opportunity to share my thoughts on this. So I vote for the motion of Senator Marcoleta.
Secretary will proceed.
Senator Cayetano Pia.
I vote yes, Mr. President, and I will explain my vote.
The lady may proceed.
Thank you. Why are we here today? Why do I have to cast my vote? It is because a group of citizens, including the members of the House of Representatives, exercised the right to impeach an impeachable officer. Under the Constitution, there are 2 ways to file a verified complaint for impeachment. Article 11, Section 3.2 by any member of the House of Representatives or by any citizen. And Article 11, Section 3.4 by one-third of all members of the House of Representatives upon a verified complaint or resolution. There were 4 impeachment complaints filed. December 2, December 4, the 3rd on December 19th, and the 4th complaint was endorsed by 215 members of the House on February 5, the last day. On February 18, 2025, Vice President Sara Duterte filed a case with the Supreme Court to question procedural and substantive due process. Her arguments: the House of Representatives circumvented the constitutional 1-year ban rule on initiating impeachment proceedings. I won't go into the details, Mr. President, but I will submit my full speech into the record. Vice President Sara's prayer was for the Supreme Court to issue a TRO as well as a writ of preliminary injunction to enjoin all respondents from proceeding with the impeachment trial. after proper proceedings, issue a final injunction, nullify and set aside the fourth impeachment complaint, declare the one-year bar to be applicable from the filing of the first impeachment complaint, declare the fourth impeachment complaint to be violative of the one-year bar under Section 3.5, Article 11 of the Constitution. Sa madaling salita, ang prayer po ni Vice President Duterte ay pigilan ang impeachment proceedings dito sa Senado. In the comments of the HOR, they argued the complaint is not barred for the following reasons. None of the first three impeachment complaints were referred to the House Committee on Justice, which effectively ended the initiation process. And two, Petitioner Duterte is stopped from questioning the freezing of the first three impeachment complaints for not immediately assailing it. Ano naman ang sinabi ng Supreme Court? The Supreme Court said the articles of impeachment transmitted by the HOR to the Senate based on the fourth impeachment complaint is barred by the one-year rule under Article 11, Section 3.5. It is also constitutionally infirm and therefore null and void ab initio. Ang ibig pong sabihin, hindi na dapat ituloy pa ang impeachment proceeding na ito dahil ang impeachment complaint na isinumite ay labag sa one-year bar rule na nakasaad sa Constitution. Ang probisyong ito ay naglalagay ng limitasyon na isang impeachment complaint lamang ang maaring maisulong sa loob ng isang taon. Dahil sa paglabag na ito, ang impeachment complaint na ito ay itinuturing na labag sa konstitusyon at walang bisa mula sa simula o tinatawag na null and void ab initio. Mahaba po yung diskusyon ng Supreme Court dyan. Makikita ho yan dun sa kaso. Dun na lang ho sa isusumite ko. Mababasa po doon yung ine-emphasize ko na provisions. So in final, sabi ng Supreme Court, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. And this decision is immediately executory. Ano ho ba ang ibig sabihin ng immediately executory? Ibig sabihin po nito na notwithstanding the filing of a motion for reconsideration by the House, the Supreme Court's decision is immediately executory such that the MR will not stay the decision. Katulad po ng sinabi ko kanina dun sa press briefing ng Supreme Court, after mag-file ng motion for reconsideration ang House of Representatives, inulit pa rin ng Supreme Court na immediately executory po ito. Ano ba talaga ang karapatan ng Supreme Court na makialam dito sa impeachment case na ito? Well, ito po yung tinatawag na judicial powers ng Supreme Court. The Constitution expressly grants judicial power to our Supreme Court. Article 8, Section 1 of the Constitution provides that judicial power includes the determination of whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. Sinabi po dito, any branch, kasama po dyan ang Senado. Pwedeng sabihin ng Supreme Court na may grave abuse ang Senado. Pwedeng sabihin yon. Pwede niya ring sabihin sa House yon. Pwede niyang sabihin sa kahit anong branch of government. Yan po ang nakasulat sa ating Constitution. In Francisco versus House of Representatives, the Supreme Court ruled that and the judiciary in turn with the Supreme Court as the final arbiter effectively checks the other departments in the exercise of its power to determine the law and hence to declare executive and legislative acts void if violative of the Constitution. So sinabi talaga dito, possible na ang Executive Act, ang Legislative Act ay maging void. In case of conflict, the Judicial Department is the only constitutional organ which can be called upon to determine the proper allocation of powers between the several departments and among the integral or constituent units thereof. The House of Representatives urged the Supreme Court to exercise judicial restraint. Sabi ng House, hinay-hinay lang, Supreme Court, so that you can avoid encroaching upon the powers of the legislature and violating the principle of separation of powers. However, the Supreme Court in Duterte versus HREP held that there is a clear and demonstrable textual commitment in the Constitution for the court to act on any grave abuse of discretion of any branch or instrumentality of government. This includes the House of Representatives or the Senate in their exercise of their prerogatives with respect to the process of impeachment. Grave abuse of discretion from the provision does not mean actions without jurisdiction. It includes acts which originally may have been within their discretion, but subsequently the subject of a violation of a constitutional right. This is what is meant by excess of jurisdiction. This court does not decide whether and when to initiate a case of impeachment. However, the court has the power to decide how the provisions which limit the exercise are to be interpreted. On due process, numerous Supreme Court decisions expound on procedural due process in various contexts. These cases underscore the Supreme Court's enduring commitment to uphold procedural due process as a safeguard against arbitrary government action. Bakit po pumasok itong issue na due process? Kasi sinabi ng Supreme Court, hindi naman nagkaroon ng pagkakataon ang Vice President na makita ang complaint sa kanya, hindi rin nakita ang mga ebidensya. Due process exists kahit saan daw pong parte ng paggogobyerno natin. Based on the decision, in order to proceed with the impeachment proceedings, the House prosecutors must show not only a valid ground thereof, but also that procedural due process has properly been observed. As this safeguards individuals from the arbitrary exercise of government power by requiring adherence to fair procedures. As such, when there is a violation of due process as enshrined under the Constitution, the case must be dismissed. Kailangan ba ng Senado sumunod sa Korte Suprema? Sinabi ko po at uulitin ko na ang sabi ng Korte Suprema, void ab initio nga po ang kaso. Walang bisa. In Latin, void ab initio means void from the beginning. Sa umpisa pa lang, void. It indicates that something was never valid or legally effective from its inception, rather than becoming invalid at a later point in time. So sa umpisa pa lang, invalid. Hindi siya naging invalid later on, invalid siya sa umpisa pa lang. Absolutely non-existence from the very beginning. Yan ang ibig sabihin ng ab initio. Null and void. It produces no rights, imposes no duties, and affords no protection. It has no legal effect. It is, in legal contemplation, inoperative, as if it has not been passed. As such, it cannot justify an official act taken under it. Yun po ang basihan ng aking desisyon. It cannot justify an official act taken under it. Hindi ho pwede nating pasukin. Gustuhin man natin alamin. Kapareho ho ako ng napakaraming kababayan natin na gusto nating alamin kung ano ba ang mga issue na to. Pero sabi ng Supreme Court, hindi ho natin pwedeng gawin yon. We have to follow the rules. At idadagdag ko, nang sinabi nga ng Supreme Court, ay ito ay immediately executory. Again, the decision stated the Senate did not acquire jurisdiction to convene itself as an impeachment court. As such, there is no constitutional authority to even convene as an impeachment court. I am a member of the Senate and I am a lawyer. I am bound by my solemn oath. Nag-oath po tayo last week lang. Ang sabi dun sa oath, I will well and faithfully discharge to the best of my ability the duties of my position. Ginusto ko ba to? Do I want to be a judge here? Hindi po. Nung nag-aral po ako ng law, sabi ko, Lord, wag niyo akong gawing judge. I hate being a judge. Malambot po ang puso ko. Kung pwede, lahat innocent. Yun ho ang gagawin ko. Kasi napakahirap humusga ng ibang tao. But this is my solemn duty. It is my duty. I took an oath. And therefore, gustuhin ko man o hindi, I have to make a decision. And binabase ko ang aking desisyon kung ano ang sinabi ng Supreme Court. Yun naman po aming lawyer's oath. I do solemnly swear that I accept the honor, the privilege, duty, and responsibility of practicing law in the Philippines as an officer of the court in the interest of our people. I declare fealty to the Constitution of the Republic of the Philippines. Idudugtong ko yung oath na yon dun sa sinabi ng Supreme Court na kailangan sundin ang Constitution. At siya ho ang magpapaliwanag kung paano i-interpret ang Constitution. My duty as a senator and as a lawyer is to be guided by evidence, by the rule of law, and by the principles enshrined in our Constitution. For these reasons, Mr. President, I cast my vote as yes. Thank you.
Thank you, Senator Pia Cayetano. Secretary.
Senator De La Rosa.
Senator Ronald Bato de la Rosa is recognized.
Mr. President, I vote yes to the motion of Senator Marcolita, and may I be allowed to explain my vote? Thank you, Mr. President. Last June 10, a day before the 19th Congress adjourned sine die, I stood on the same spot conveying my serious concerns on the constitutional infirmities surrounding the articles of impeachment that the 19th Congress of the House of Representatives transmitted to the Senate. I pointed out that the circumstances surrounding the filing of articles of impeachment seem to violate the one-year bar rule enshrined in Article 11, Section 3, Paragraph 5 of the Constitution, among others. Given this patent violation of the Constitution, I made a motion to dismiss the articles of impeachment against Vice President Sara Duterte. After a long discussion with the members of this chamber of the 19th Congress, I listened and I learned my motion for dismissal was amended by Senator Alan Cayetano and became a motion to remand. The impeachment court then ordered the remanding of the articles of impeachment to the House of Representatives. This chamber also requires the 20th Congress House of Representatives to communicate whether or not they are willing and ready to pursue the impeachment complaint, a requirement which until now has not been complied with. In a sudden shift of events, before the opening of the 28th Congress, the Supreme Court took all by surprise when it promulgated their decision on petitions challenging the validity of the articles of impeachment against Vice President Duterte. When the Supreme Court released their decision to the media, many people expressed their views. There are those who celebrated and commended the Supreme Court. Others voiced out their disappointments. Some criticized the decision. The mixed reactions seem to suggest that the decision promulgated lacks clarity. And yet, Mr. President, after reading the decision, I asked myself, is it long? Yes, 97 pages to be exact. Is it vague? No, Mr. President, it is clear as day. According to the plain meaning rule or verbal leges, if the statute is clear, plain, and free from ambiguity, it must be given its literal meaning and applied without interpretation. Now, even though the decision of the Supreme Court is not a statute, it still forms part of the legal system of the Philippines as mandated by Article 8 of the Civil Code of the Philippines. Since the decision of the Supreme Court is clear, plain, and free from ambiguity, applying the plain meaning rule, it should be given its literal meaning. That is, the articles of impeachment are unconstitutional. The Senate did not acquire jurisdiction, and the decision is immediately executory. Plain and simple. Kaya naman, Ginoong Pangulo, nagulat ako nung ako'y tanungin, susunod po ba ako or tayo sa desisyon ng Supreme Court? Hindi po ganun kataas ang tingin ko sa aking sarili. I honestly do not place myself in a position so high, too high, that I will be the one to be asked if I will obey the Supreme Court's ruling. Ang nakasaad sa ruling na yon, immediately executory. Wala namang postscript or PS sa baba na nagsasabing subject to your review and further evaluation. As a member of the Senate and as a citizen of this republic, I submit to the authority of the Supreme Court and respect its decision. Perhaps in shedding light on the highest court's duty, the integrated bar of the Philippines said it best, and I quote, "As the final arbiter of constitutional questions, the Supreme Court bears the solemn duty to interpret the law, determine its bounds, and clarify its implications, even when it revisits past doctrines or addresses new context. This authority is rooted in checks and balances, the very design that guards against the excesses of any branch. Mr. President, the rule of law is the foundation of our democracy. And if we are to be models of upholding the law, then it behoves us to listen and heed those who have been tasked by the Constitution to interpret the Constitution. The interpretation of the law remains lodged with the Supreme Court, and we must abide by its decision. What message would we send out to our people if we, legislators, will not honor the wisdom of the highest court in the land? Are we not, in effect, promoting anarchy? I want to believe that indeed we are men and women of the law, that we live by rules and perform our mandate as elected officials within lawful means. Our people rest easy and feel a sense of security because their Senate has remained to be guardians of democracy. Looking back, the Senate has accepted several Supreme Court decisions in the past. Why should the ruling in this current impeachment case be any different? Is our concept of respect for and acceptance of Supreme Court decisions selective? If that is the case, are we not playing with fire? Fire, mind you, does not always intend to enlighten or illuminate. It can also burn and bring a house down. Much has been said about where I stand, and I understand that my positions on certain matters have always been consistent and transparent. But while the public and this chamber may be familiar with my views, all that is simply driven by what is in my heart. And I say this with humility. My heart has always been guided by what is right, not only when it is easy, not only when it is convenient, but even and especially when it challenges my comfort zone, when it no longer serves our side. Because at the end of the day, it is a matter of principle, not popularity. Perhaps sometimes we ought to protect our democracy, even from ourselves. Of course, the Senate is not a mere follower of the Supreme Court, but a co-equal branch, meant to respect the powers and functions of the latter in its decisions. I trust that the Senate will continue to peacefully coexist with the Supreme Court. Let us not allow this impeachment trial to become a venue and opportunity to disrupt our system of government. I hope this is not the time when we dance differently, when clearly the same song is playing. We must follow the Supreme Court ruling, not because it is the most convenient thing to do, but because it is what is right and just, no matter how unacceptable or painful it may be. And this is why, Mr. President, I vote yes to adhering to the Supreme Court decision. Thank you, Mr. President.
Thank you, Senator De La Rosa. Mr. Secretary.
Senator Ejercito.
Senator Ejercito is recognized.
Yes, Mr. President, I likewise vote yes to adhere to the Supreme Court.
Thank you, Senator Ejercito. Secretary.
Senator Estrada.
Senate President.
Senate President Escudero.
The Senate President is recognized to explain his vote.
Thank you, Mr. President. Distinguished colleagues, sa mga minamahal nating kababayan. For many of us, the past 2 weeks have proven to be an exasperating, mentally and emotionally exhausting experience. Both sides have fought bitterly a dialectical struggle to articulate what they respectively believe to be the correct position or view on the issues involved. Passions had run high as demonstrators, whether for or against impeachment, took to the streets armed with their familiar slogans and chants to air their voice on the matter. Various sectors of society, from business, retired military, academe, denominations of faith, offered suggestions for a return to a state of normalcy in the official relations of governmental branches. Through all these, and as early as the time when the articles of impeachment had been constituted, the court was specifically asked told, urged, and argued to take no action of any kind and form with respect to the prosecution by the House of Representatives of the impeachment complaint. When the present petitions were knocking, so to speak, at the doorsteps of the court, the same clamor for non-interference was made through what are now arguments of lack of jurisdiction, non-justiciability, and judicial self-restraint, aimed at halting the court from any move that may have a bearing on the impeachment proceedings. The court did not heed the call to adopt a hands-off stance as far as the question of constitutionality of initiating the impeachment complaint is concerned. What lies in here, is an issue of genuine constitutional material which only the court can properly and competently address and adjudicate in accordance with clear-cut allocation of powers under our system. The claim, therefore, that the court, by judicially entangling itself with the process of impeachment, has effectively set up a regime of judicial supremacy is patently without basis in fact and in law, because it is not at all the business of the court to assert dominance, judicial dominance, over the other two great branches of government. Rather, the raison d'etre of the judiciary is to complement the discharge by the executive and legislative of their own powers to bring about ultimately the beneficent effects of having founded and ordered our society upon the rule of law. Mr. President, distinguished colleagues, the institution that is the Supreme Court, together with all other courts, has long held and been entrusted with the judicial power to resolve conflicting legal rights regardless of the personalities involved in their suits or actions. The court has dispensed justice over the course of time, unaffected by whomsoever stood to benefit or suffer therefrom, unafraid by whatever imputations or speculations could be made to it, so long as it rendered judgment according to the law and the facts. No one is above the law or the Constitution. This is a basic precept in any legal system which recognizes equality of all men before the law as essential to the law's moral authority and that of its agents to secure respect for and obedience to its commands. Perhaps there is no other government branch or instrumentality that is most zealous in protecting that principle of legal equality other than the Supreme Court, which has discerned in its meaning and ramifications through its application of numerous cases, especially the high-profile kind in the annals of jurisprudence. The Filipino nation and its democratic institutions have no doubt been put to a test once again by this impeachment case. Accordingly, the court resorted to no other than the Constitution in search for a solution to what many feared would ripen to a crisis in government. Sa muli, magandang gabi po sa ating lahat. Hindi ko po salita mga sinambit ko na ilang minuto. Yun po ay paraphrase at halos eksaktong quotation ng salita ni dating Justice Conchita Carpio Morales sa Francisco ruling na kinatigan ng mayoriya ng mga miyembro ng Korte Suprema, kabilang na si dating Chief Justice Puno, dating Justice Carpio, dating Justice Ascuna, dating Justice Panganiban. Ano nga ba itong Francisco ruling na pinag-uusapan natin ito? Ano nga ba ang pinagkapareho, pinagkaiba nito sa kasalukuyan nating hinaharap? At bakit ko ba ito tinatanong? Ginoong Pangulo, bahagi ako ng Kongresong nagtangka na i-impeach si dating Chief Justice Davide. Bakit ko sinabing tangka? Dahil pinigilan po kami ng Korte Suprema. In-enjoin at nag-issue ng TRO ang Korte Suprema at ito yung desisyong yun. Francisco case na palaging sinasite po natin. Ano bang pinagkapareho? Ang aligasyon laban sa nasasakdal noon na si Chief Justice Davide, kaugnay din ng corruption. Daang milyon din. Ang pinag-usapan, initiation of impeachment, na dapat sole prerogative din ng Kamara. Ang pinag-usapan, ano bang definisyon ng initiation, na dapat sole jurisdiction din ng Kamara. Ang tanong ko po ay simple. Noong mga panahong yun, nasaan po lahat na nagre-reklamo ngayon at nagko-question sa desisyon ng Korte Suprema? Yung mga maestradong nagko-question ngayon na retirado na, bumoto sila pabor doon. Subalit ngayon, tila nag-iba ang posisyon. Ano nga ba ang pinagkaiba kung meron man? Klaro ang pinagkaiba. Iba ang pangalan ng nasasakdal. Today, Mr. President, distinguished colleagues, the very supremacy of the Supreme Court is being called into question, and with it, the very foundation of the rule of law. As Senate President and as a member of this chamber and as a member of the bar, I will not sit idly by and allow this. At stake is the very idea that justice should be governed by laws that apply to all, equally to all, rather than the whims and caprices of public opinion. As Justice Frankfurter once said, if one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Legal process is an essential part of democratic process. Whether it's a mob or a minority, bias and prejudice blinds, divides, and destroys. Former U.S. Supreme Court Justice Sandra Day O'Connor also said it best. The law provides necessary continuity amidst our constantly shifting political landscape. It guarantees everyone will be treated equally, whether they are in today's or yesterday's majority, so they know what to expect, whether what they do is popular or unpopular at that time. The courts, Mr. President, with the Supreme Court at the helm, are the guardians of the rule of law, making sure everyone plays by the same rules and receives equal justice. For the rule of law to prevail, the High Court must act as a compass, not as a political cheerleader, impartially applying the law by calling out violations, not swayed by public opinion or political allegiance. Respect for the rule of law, Mr. President, requires all of us to adhere to final or immediately executory decisions of the court, even when there is a winner and a loser, to avoid deadlocks and maintain legal order. Respect for the rule of law does not bar disagreeing with court decisions, nor from forming our own opinions on the meaning and intent and letter of the spirit of the Constitution. However, we must also have the humility to accept when we are wrong once the Supreme Court has already decided. Respecting the court only when you win or when it aligns with your belief is not respect for me. It is plain arrogance, or if at all, a power play. Cherry-picking court rulings destroys the judiciary's purpose. Disobeying the High Court's decision is a violation of the law, because under our Constitution, decisions of the Supreme Court form part of the law of the land. I made these remarks, Mr. President, amidst recent calls for this august body to disregard the Supreme Court's recent ruling in Duterte v. HOR. These calls for judicial disobedience